the subject matter proper, I want to figure out from you what your initial reaction was when you heard that the president has dismissed the Chief Justice.
Well, thank you and good evening to you. I was not surprised because once a petition of this nature has been submitted, there are only one of two outcomes that we can expect. And the two outcomes are that he would be exonerated and asked to go back to work, or he will be found guilty and be dismissed or recommended for dismissal by the committee. And so I was expecting an directive.
Well, now the verdict is clear. She has been dismissed. Now, right after that verdict was made, particularly on social media, quite a number of people were saying that, well, President Mahama literally only got that, recommendations today from the committee set up, and he already dismissed the Chief Justice. Do you think that President Mahama perhaps acted a bit too swiftly to enact the recommendations by the committee, as in that it was too fast? Perhaps he should have taken his time to go through and even wait for other recommendations to come in before he acted on that recommendation. From where you sit as a lawyer, can the speed of such judgments have any impact in any way, shape, or form?
Well, when you look at the text of Article 146, the president is not the one, in fact, removing the Chief Justice. Once the committee recommends that the Chief Justice should be removed, the president is only like a rubber stamp, so to say, under Article 146. Because the law says that he shall comply with the recommendation of the committee. And so you would agree with me that as a matter of fact, it is the committee that has the power to either remove the Chief Justice or not remove him. So if you are the president who has no discretion, who has no influence, and who has no power, then it stands to reason that as soon as the committee makes their recommendation, you're better off just enforce their recommendation so that it will leave your table and you have other things to do.
Now, I also want to find out from you, talking about this removal in particular, Article 1466, what precedent does this set? So does it mean that when there is any issue whatsoever, someone can just write or petition for the removal of the Chief Justice? And what does this mean for future Chief Justices when some of these, complaints or what is the legal term, if you can help me out with that, when people file petitions for the removal of any Chief Justice, how can they be protected from any meager, petition to be removed? Because once that article is there, it means that anyone at any given point can trigger it. Is that the case?
Yes. So I was telling I was speaking on another platform, and I said that until 1947 or so, the USA, which had practiced democracy for almost 150 years, they did not have a provision in their constitution which prevented the president from going for a third term or a fourth term. Until Franklin Roosevelt became president, then he went for the third time and won. He went for the fourth time, won. And then he died in office. And as soon as he died, the USA Constitution was amended. And they made sure that if you are the president, you cannot contest for more than 3 times. And so the question I've been asking myself is, will Ghana be able to use Justice Gertrude Torkornoo as a catalyst to amend our constitution? Because as we speak now, the president has not breached any law in this country. However, you and I will agree that this procedure does not help the separation of powers and independence of the judiciary. And so Whilst no law has been raised, I want to argue that it is time for us to really look at the 146 and see how we can fortify the office of the Chief Justice and insulate that office from interference or removal from politicians. Otherwise, the moment I write a petition to the president and the president is minded to forward the petition, the Chief Justice will go in future. And that will not help our democracy as a country.
So then that takes us to the Constitutional Review Committee that, in particular, Article 146 should be taking a look at, a critical look at. But where you sit as a private legal practitioner, what recommendations may you have, in regards Article 146 in protecting, future chief justices, etc., so that some of these petitions to remove them would not be as straightforward and they are somewhat insulated?
Well, there should be immediate recommendations and then long-term recommendations. One of the immediate recommendations I have made and I want to make again is that there should be a CI, a constitutional instrument, that would elaborate and explain how the Article 146 provisions must be applied. Now, when we have this CI, which is into details, it will be able to give step-by-step process that we can use to go through processes like this to either remove or not remove the skill. I think that one, it can be done immediately if there's that political will and cooperation between the judiciary and the executive. Now, in the long term, we are lucky that the Constitutional Review Committee is still working. I think that any purported petition for removal of the CJ should not even go to the president at all. We can set up another higher body that will be there to supervise the judiciary without any interference from the executive. Because believe you me, whether the petition is meritorious or unmeritorious, the moment it goes to the president, it raises political questions. And once it raises political questions, whether the process is fair or not, we shall always look at it with political lenses. So I believe the presidency should be taken out of the process completely.
But counsel, isn't that counsel, isn't that also taking away some powers from the president, because you're asking for an independent body, which I assume would entail perhaps lawyers, judges, etc., to kind of like take a look at some of these cases. But in doing that, aren't you also limiting the powers of the president, as this might be an executive order?
You see, we have to draw a fine line between giving executive powers to our president and holding the balance of power in the country. The judiciary is one of the pillars of this country, which helps us to hold the balance of power. If tomorrow, for example, the president gets up and says that you are too fair than him, you should be arrested and executed, it is only the judiciary that you can have hope in to be able to restrain the president from doing that. So if we end up giving powers to the president, that the president can get up and remove anybody from the judiciary, then at the end of the day, we have no protection nor balance of power in this country. So I will, on any day, support any amendment that will remove that power or that responsibility from the president. In any case, we have all agreed that the president of Ghana has too many powers, and we need to reduce some of those powers in order to ensure that there's fair balance in power and that the executive is accountable to the people.
Right. Now, we know that when you have a decision made that you do not like in the courts, you can then proceed and go to the Supreme Court for, an appeal, or courts of appeal, for example. In this case, where the president has made the decision, what other options does the Chief Justice have? Does it end here? Can she, sort of appeal to the president to perhaps, change his mind? What are the options the Chief Justice has in this regard to, for lack of a better term, overturn this decision by the President?
In fact, when the Chief Justice went to court from the beginning, I'm on record to have said that she rushed or she jumped the gun. As a matter of fact, this is the time that she can go to court. At the time she went to court, she actually rushed because this committee is a quasi-judicial committee. And under our laws, any committee that is a quasi-judicial committee is subject to judicial review by both the High Court and the Supreme Court. So at this point in time, if the Chief Justice feels or she has evidence to show that some rules of natural justice were not followed and that the committee did some laws and did not do it, this is the time that she can go to the Supreme Court for the Supreme Court to quash the work that the committee did.
But now that she had already been there, there's nothing she can do about it. But you recall that she also went
nothing prevents her from going out.
Oh, she can still pursue that?
She cannot go again.
Okay. And in any case, can the Supreme Court, challenge the President's decision, for example?
Of course, the Supreme Court is the highest court in the constitutional court of this country. And so, if they have reason, legal basis to believe that the committee and the President erred in what they did, the Supreme Court is so empowered to make that pronouncement and ensure that there's a reversal of the wrong.
Interesting. So let's assume that she goes to the Supreme Court and they are still not in favor, or they are in favor of the President's decision or judgment. What next for the Chief Justice? Is she forced to retire? What happens to her? What happens to her, really? Because once she loses that position as a Chief Justice, does it mean that she has to retire and go home? Or she can't still act in a capacity? If so, in what capacities can she act in?
Well, if the Supreme Court disagrees with her, too bad. That is the end of her case. Now, as to whether she can act in other capacities, I think the law is not too clear. I am of the view that when you are removed as Chief Justice, it does not mean that you have been removed as a Supreme Court judge. But that is my personal view. There are other lawyers who disagree and say that once you are removed as Chief Justice, you have also been removed as Supreme Court judge. And so I think we are all learning. We need to see, and in the coming days, we will know what will become of her.
Interesting. So we might see the end of Chief Justice Araba Torkornoo, basically.
That is so, because once she has been removed as Chief Justice, and if it also holds that she been removed as Supreme Court judge, then unfortunately, that is the end of her career. And it will be a sad one, because if she retired as a Supreme Court judge, she was going to retire on her salary. What that meant was that she would be receiving the same salary she was getting until the Lord calls her. But once she has been removed, I want to believe she's going to lose all those benefits, which I believe is quite harsh and painful, looking at all the sacrifices she has made to get to where she got to.
Interesting. But let's take you back to how we got here. Let's look at some of the specific, issues filed by the petitioner, the specific allegations filed by the petitioner, Daniel Ofori, which kind of like started this entire process for the removal of the Chief Justice. So first in 2023, the allegation was that the Honorable Chief Justice misappropriated the sum of 261,890 cedis of public funds for the benefit of the Chief Justice and her private foreign travel with her husband, Francis Kofi Torkornoo, as well as her daughter, Edem Torkornoo, as well. Now, the second allegation is that in the same year of 2023, the Chief Justice misappropriated a sum of 75,580 cedis out of public funds for Ethiopian airline tickets for her and her husband during a vacation of the leadership to Arusha in Tanzania. Again, the third, which should pop up in a bit, also in the same year, talks about the fact that her leadership obtained from the Judicial Service an accountable imprest in the sum of 14,000 United States dollars to travel with her husband to Arusha, which he failed to retire. So it seems, I don't know, I want to get your thoughts on this once again, counsel, with some of these allegations leveled against the Chief Justice. From where you sit, do you think that it warrants her outright removal?
Well, it depends on how you look at it. Let me give the caution that I have not seen the report of the committee. So my comments on these specific applications will be very limited.
Right.
Because I don't know which one of them was proved and what kind of evidence was led at the committee hearings. But basically, if you are the Chief Justice of this land, then it behoves on you to uphold integrity and fairness and rightness at all times. And so the allegations in this petition are that she traveled with her private family at the time that she described the travel as official travel. It was not supposed to have been official travel. Now, these things might seem very minute and small, but if you think about it on a wider spectrum and a deeper analysis, these are some of the little things that bring the country the name of, let's forgive, forget, and let it pass. And so I want to believe that if anybody wants to be very critical of her, and indeed this information turn out to be true, then it is duty bound on that person to ensure that an example is set so that other persons who are below her rank, who are in the habit of doing some of these things, will become careful, knowing that if it even happens to the CJ, then it can happen to me also.
Well, I want to thank you so much for your time, private legal practitioner Richard Niama, helping us with the education on the removal of the Chief Justice and his thoughts on the entire process and some recommendations for the Constitutional Review Committee, in particular, Article 146, which allows virtually anyone to be able to petition to remove the Chief Justice. Well, you're still watching News Nights, coming to you live from our studios here at Aveda. We'll take a quick breather. When we're back, we'll take